Today, what happens when your beneficiary dies, and even better, how to be prepared so your plan works, even if that unforeseen, unexpected thing happens. So I met recently with Amanda, who's been a client of mine for a few years. Her husband, Neil, died young. Cancer got him, and she's left as a young widow with two small kids. It's been 3 or 4 years since Neil passed, and she's been getting through with a lot of support from her siblings and Neil's family. His mom, Irene, really pitched in to help with the kids. She's older, and Irene several years ago had bought a life insurance policy that benefited Neil and her 3 other kids, so a quarter for each of them. Well, Irene passed away here recently. It turns out that since Neil's death, she had not updated the beneficiary designations. The way it was originally set up with her financial advisor, the custodian of the account, was that the portion that was to go to Neil would go to Neil's descendants. Well, these kids are both under 10. And so Amanda was back in my office because state of Georgia, and no other state, and I don't think any other custodian of funds will let somebody under 10 inherit. So we're working with her to get a conservatorship, an underage conservatorship with the courts here in Georgia. And that's pretty typical across the states. And this conservatorship would be one that would go until the age of majority. But what it really brought to my attention was there are these situations where people have beneficiary designations set up on accounts, and it could be insurance policies like Irene had. It can be investment accounts. It could be any number of things. It could be POD on bank accounts, could be a transfer on death deed. But there's uncertainty as to what happens if those beneficiaries aren't there the way you expect them to. So today we're going to talk about what happens when a beneficiary dies, predeceases you, what occurs. And more importantly than talking about what happens, I'm going to tell you what to do about it, how to be prepared. So if that occurs, you're not in a situation like Amanda getting set up these conservatorships for the kids, which is a less than ideal situation. She's going to have legal costs, court costs. She's going to have to ask the court if she wants to spend this money for Neil's kids for after school soccer or for school supplies or whatever it is she wants to spend it for in a few years. Helped buy a first car for him, any of those things that she needs the money for. She's got a partner in this now, which is the probate court judge, who's a fine person, but not really somebody that Irene would have picked to be involved here. Irene loved both Neil and her daughter-in-law, Amanda, and would want her to be able to do with the money what she thought was best for the kids. And that's just not the situation we're in. And my least favorite thing, and I've got a whole other episode about conservatorships for young kids, is that when the kids turn 18, the court says, we're out of it. You got to give the money now to the kids. And if you're interested in that, or go track that episode down. My name is Jim Miskell. This is Let's Talk Estate Planning. I am a lawyer in the state of Georgia for more than 30 years. And even though that's true, this is a podcast. It's not legal advice. Legal advice happens when you sit down with a lawyer and you pay them to listen to you and to give you some feedback on your situation. The first answer you're going to get from any lawyer when you ask them a question, of course, is it depends, but it depends on other details. And when you're consulting with a lawyer, those other details are what the lawyer's going to start asking you questions about. She's going to start asking you about the things that matter so that she can give you a good read on your situation and some good advice. This is a podcast. It is for informational, hopefully a little bit of entertainment value. I think estate planning is so important to families that it's better for you to be informed about it so that you can go make good decisions when you meet with experienced estate planning attorneys to put your own plan in place, but you go in with a vocabulary and hopefully some good ideas. So information, entertainment, education, not legal advice. That's my required disclaimer. Now back to the subject at hand today. So when the unexpected occurs and a beneficiary you've designated through another instrument passes away before you do, what happens when you go? Well, it could be any number of things. The situation we've talked about with Irene's policy was that it was set up to go to each of her kids and their descendants. That's not always an available option. So there's really, let's go through it. There's about 4 different things that can happen. And the first is, let's say you name a number of people to be beneficiary on an account or an insurance policy, that sort of thing. And one of them's predeceased. In some situations, that share, if it's like Irene, 4 people, one's gone, it's just going to be thirds to the other 3. And that branch is just extinguished. And they call that a lapse. That share just lapses. It goes back in the pot and gets divided equally among the others. So that's one possibility. The next possibility is that it could go to the deceased beneficiaries' heirs. Descendants per stirpes is what you normally see on that, but that's getting at that idea. Or it could be heirs. This depends on what the policies are on that particular product, on that account policy, or what the custodian of those funds has as their internal policy. So it could then go to that deceased beneficiary's heirs, which might be what you want and may not. The next thing that could happen is, rather than lapsing and going back in the pot, what could happen is that 1/4 now is kind of orphaned. It's out there. It's not going back in the pot, and it's going to go into your estate. If you've got a will plan, or let's say if you've got nothing, that means it's intestate succession at the probate court. If you've got a will plan for your inheritance, well, then it's going to go in the pot of the estate at probate court. If you've got a trust plan trying to keep things easy for the family and well organized so they don't have to go to probate, too bad. That's going to probate because it's going into your probate estate. So none of those options is probably what you had in mind, although one of them may be. The question is, which one do you have? That's a great question. I have people ask me this all the time. I'll sit down in a room with folks and learn a lot about them and what's important to them. And it'll come time to do their plan. And they say, well, all right, how's this going to work? And I always turn back to them and say, how do you want it to work? One of the real strengths of estate planning is that it doesn't have to work like anybody else's. It can work however each individual family needs it to work best for them, which means any of these options might be right, and you get to decide what that is. Hey, Jim Miskell here. Sorry to interrupt the episode. Hope you're enjoying today's content. A lot of times when folks are thinking about this kind of thing, questions spring to mind. If you have questions, we like to do some question and answer episodes. So you can go to our website, letstalkestateplanning.com, and shoot us a message and say, hey, on the podcast, I'd like Jim to cover this on the next question and answer session. Or if it's hitting closer home, especially if you're a Georgia resident, of course, we can't give legal advice on the podcast because it's not specific for your situation. But if you got a situation that you need to handle, it's important to get that done. So letstalkestateplanning.com is how to contact the office. I'd love to talk with you about the specifics of your situation and make sure your estate plan is everything that your family should have it be. In the meantime, we're going to go back to the episode. Thanks for tuning in, and I hope to talk to you soon. So if I were to ask you, how's it set up right now for you and your family? You don't know. If you knew, you wouldn't be following this episode. So that's my point, is when you met with the financial advisor or set things up with HR, when you set up those, the retirement account, or when you bought that insurance policy, all those things, you remember you did something, but you're not really sure what it is. Well, those details really matter. With estate planning, you can have it come out however you want to. What happens is people get surprised because of the nuances. It might go to, you might have one contingent beneficiary, but there may not be an automatic default contingent. If they're deceased, what happens with that particular product? Does it lapse and go back in the pot? Does it go to heirs, descendants? Does it end up in your estate? Does it end up in their estate? This is the time to go find out, because it can do anything you want it to. And if you knew what that was, you'd be doing something else now instead of listening to me. So this is where I'm going to advise you, go back to your financial advisor. Go back to HR at work if you're still working in the workplace. See how your beneficiaries are set up. What does it mean if one of them predeceased you? Because it can be different from provider to provider. It doesn't really matter which it is. It's just that you know which it is and whether or not it's the way you want it to be. You may have the ability to put descendants per stirpes on there. You may have had the ability to do that when you set the thing up. Whoever was working with you that day may not have thought of it, may not have walked you through all the possibilities. This is where beneficiary designations can often fall short of the planning that you can do in a will or a trust with testamentary planning. Testamentary trust planning allows you to set up the rules and guidelines for the gifts that you give at your death. And almost as important as the rules that govern them when they're given is you can do any number of what ifs for those gifts. If this occurs, then do that. If this occurs, then do this. If that occurs, then do this. The if-thens are just a lot more robust when you're doing testamentary trust planning than when you're working with a beneficiary designation form, which very frequently looks like just a page with 3 or 4 blank lines that you can fill out. And they may have one level of contingencies you can put there. They may have 2 levels of contingencies that you can put there, but it may not be as robust as you feel like your plan ought to have. So this is a definite advantage of having an estate plan that distributes through trusts or wills, has an advantage over bare beneficiary designations. And a lot of folks can get hung up on, I want to stay out of probate, and I'm going to do that through beneficiary designations. And that's fine. They do what they say they're going to do, but they're not as robust, as I've said, with contingencies, the if-thens that can occur. So for the strongest plan, in this situation with Amanda, who lost her husband, Neil, it would have been great if Irene, Neil's mom, had had that insurance policy go into a living trust so that the if-thens would be covered. What happens if you've got a disabled beneficiary? We could have that money held for them in a special needs trust. What if you've got an underage beneficiary? Do you want to rely on what the state code illustrates? In Georgia, at 18, that's where those conservatorships end. Is that the right age for people in your family? Probably not. Probably needs to be a little bit higher. But had I been able to have a conversation with Irene, what I would have urged her to do was let's think through those contingencies that could very well happen. And unfortunately, she'd had a real life example where she'd already had Neil predecease her. And thankfully, that doesn't happen to as many of us as it could, but it could happen to any of us. And the folks for whom that has already become a reality, where something breathtakingly unexpected has happened, like the loss of a child predeceasing you, they're already particularly attuned to the things that can happen and making sure that the plan still works effectively for the people they care about, even if these untoward things occur. So what happens when a beneficiary dies? It really depends. What are the policies of the custodian of that asset? If it's a financial asset, what is the state statute in your neck of the woods on a transfer on death deed? And then what do you want? So I started this episode by telling you not only that we were going to talk about what happens when a beneficiary predeceases you, but also I was going to tell you what to do. And here's that part of the episode. Go do some research. Find out how your assets are set up. The beneficiaries on your retirement accounts, your investment accounts, if you've got transfer on death or pay on death on any of the other accounts, if you've got insurance policies, retirement accounts, find out how it's set up and what happens if you have a transfer on death deed. What does the state statute say about that when there's a beneficiary missing? Sometimes a beneficiary missing means a lapse and it goes to the other beneficiaries. Sometimes it goes to a named person. Have you named that person? So part of this might be a modification of the beneficiary designations that you've got on each of those individual accounts. Perhaps a more holistic approach would be in your trust to shape the bucket. Have these accounts feed into a bucket that handles the distribution with all those if-thens in there so that things go the way you want them to. And of course, along with this housekeeping exercise, and that's really what I'm encouraging. I'm encouraging that you go ahead, do some housekeeping, find out how things are set up, and consult with experienced financial planners and experienced estate planning attorneys to make sure you get it right for your family. What's important is not how it's set up right now, but how do you want it and how are you going to get there? Very often, a more satisfactory way to do it is to build that designated beneficiary machine, that living trust that has all the if-thens in there to make sure things go the way you want it to for the people you care about. And that's why you should consult with experienced estate planning attorneys, because they've seen many, many families go through this. They have many ideas about how this will work. They're attuned to how different structures can have different tax consequences for different assets. That's where it's great to work with a team, not only an estate planning attorney, but also a financial planner in the mix so that you don't accidentally trip over any of the IRS rules. If you are in the state of Georgia, I'd be more than happy to meet with you about this. Just contact our office. It is letstalkestateplanning.com. Same as the podcast, letstalkestateplanning.com. I'm big on education. We do workshops, podcasts, blog posts that are available through our website. If you have any questions, please let us know. I'd be happy to cover them in future episodes. Until then, I'm Jim Miskell. I appreciate your time on this episode, and go check it out. Find out how your stuff is set up now and make sure that it's bulletproof, that if things that you don't expect to happen, the people that are left still get cared for the way you care for them. Thanks. See you next time.